that the trial court erred when it when it found that it could not consider Ms. Paul's request for street time credit. For purposes of argument today, I'm going to focus on just that third issue. Of course, if Your Honors have any questions regarding the other two issues, I'm happy to address those as well. As to that third issue, though, that the trial court erred when it said that it could not consider Ms. Paul's request for street time, that did used to be the case. But in July 1st, 2021, the statute governing probation was amended to grant trial courts discretionary authority to give what we commonly call street time. And the statute describes that as credit for time that was successfully served on probation. And a trial court can give credit for all of the time that a probationer successfully served on probation against any sentence of incarceration. They can give just a partial request, so if they don't think all of the credits are warranted, however they want to break it up. Of course, they can deny it outright.
How is successfully served on probation defined, though?
It's not defined by the statute.
I guess that's the way I read the state's argument is they're not necessarily taking issue with the amendment to the statute and whether this can happen. The state seems to be arguing that, yeah, but successfully serving probation, the failure to pay, the quote absconding or not reporting, those days kind of go again. You should get credit for the times that you're violating. Whereas, you know, and I don't remember the amount of time, but let's just say for the first year she was reporting and doing everything, yep, we'll give you street cred for that. But for the last 6 months when you did nothing, we're not going to give you credit for that.
I think, and ideally, and I'm happy to address this now, but I think that in a perfect world, or at least a perfect hearing, those arguments would have been fleshed out before the court. To say these times when she was on probation because she was meeting with her probation officer, she was passing her drug screen, she was making restitution payments, even if only partial, given her financial constraints, those sort of things, that all of that should count because she was successfully serving probation. The state's argument to the other side, well, she, at least after this day, you know, clearly wasn't reporting in, those sorts of things. I think there's an argument that that time doesn't count as well. I've taken that into account also in my briefing. But because the term successfully served isn't defined, I think that that's a discretionary decision for a trial court to make as to what does successful compliance look like, and to explain that as well.
The moment the warrant is issued, we stop giving you credit. You're saying this is a more unknown.
I think because it's not a defined term, that there's certainly room for attorneys on both sides to make creative arguments about what time applies and what time doesn't. I would readily admit that once a probation warrant has issued, then that time is clearly not going to apply. I would probably even say that, and I do so in my brief, that any time after September 8th, 2014, that would not apply against Ms. Paul's sentence because that is when she is first alleged to have failed to report in. So I wouldn't argue that that is successfully serving on probation because at that point she's not complied, at least allegedly. And the state has conceded that the trial court erred when it said that it couldn't consider the time. So this court doesn't have to agree with us on that, but if you do, then under abuse of discretion, you can either remand this back for the trial court to have a renewed hearing on it, allow both sides to make their arguments, allow for a presentation of proof, or if you want to conduct a de novo review, I do think that there is enough information for this court to say that Ms. Paul had successfully served time on probation and that should be credited against her sentence. I think between those two options, though, just honestly, a remand would be the most beneficial in this situation. There is information in the record about Ms. Paul meeting with her probation officer, at least from it would have been June 20th of 2008 when she first pled guilty up until April the 14th of 2011 when the first violation warrant was issued. From the records related to that first violation warrant, it's clear that she was meeting with her probation officer. She was at least attempting to pay towards her restitution. She was passing her drug screens. The only thing she was failing for were prescription medications. They're in the violation warrants themselves. There's no indication that she ever failed a drug screen. There are allegations that she was not reporting in and that she was not paying. And you can weigh that as you want, but I certainly think that there is room for a more thorough presentation of proof by either side as to what successfully served means in this case.
How long did they not hear from her?
The second probation warrant was issued in September of 2014. Or sometime around September 2014, that's when she first failed to report in. I think it was a little bit after that they issued the report. And then I think it was sometime in 2022 that she was in court to address the issues.
And how much time are you asking for?
She originally was put on to supervised probation following her guilty plea in June of 2008.
Okay, hold on a second. Wasn't she originally on diversion?
She was on diversion, but that's still supervised.
Well, I know that.
Yeah.
I'm just saying, then when she violates diversion, then she's put on probation.
There was a violation, a first violation that was issued because she had not informed her probation officer that she was no longer employed or a full-time student, and also that she was not making full restitution payments. She admitted to that violation, and I have an issue with failing to make payments toward restitution, whether that was willful. I can go down a rabbit hole on that, but I won't. But she admitted to that violation, agreed to have her diversion status removed, and an additional year added on to her sentence for her probationary term. So it went from 5 to 6 years.
So getting back to Judge Wilson's question, how much time are you asking, or do you think she's entitled to?
I think that she is entitled for time from June 20th of 2008, when she first pled guilty to this offense, up to September 8th of 2014, when she first failed to report in, which forms part of the basis for the second violation. And that would exclude the time around the first violation from April 14th of 2011, when that was issued, to June 21st of 2011, when she admitted to the violation and was reinstated at that point. I think I've covered all the points that I wanted to make on that. Unless the court has any other issues, I'll reserve.
Yeah.
Okay. Well, I would again ask that this court first vacate her revocation and remand this for a new hearing, but if you decide that that is not warranted, at least remand this matter for a new hearing as to her request for street time, or under a de novo review, grant the times that I've requested here today. Thank you, Your Honors.
Thank you. Coleman.
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the denial of or the revocation of probation and hold that the defendant is not entitled to any street credits. Unless this court has any questions about the first two issues raised by the defendant regarding the finding of a violation, which the state submits the defendant absconded for about 8 years, and that is enough for the trial court to find a violation, or the consequence imposed being full revocation, which again, the record is clear here that the court makes a finding of a violation and then has a separate hearing immediately thereafter about the proper disposition, makes its findings on the record. State would submit that that is appropriate too, and that was a proper exercise of discretion. I will move to the street credit determination. So this is an interesting case because the probation violation warrant was sworn out in February of 2015. And at that time, it was not an option to grant a defendant street credit. But because the defendant absconded for about 8 years, The hearing didn't take place until May 30th of 2023, and by then, the legislature had amended the statute to allow a court, or to give a court discretion to award street credit, as it's commonly referred to. And the statute, when it was amended, said that those that it applied to, quote, determinations made on or after the date it became effective. So it is correct. The trial court at the time of this probation revocation hearing, again because the defendant had absconded for about 8 years, had the ability and authority to impose street credits if it so desired. And its determination that it was not authorized to do so was an error, but we submit that the record is replete with evidence for this court to conduct a de novo review and find that street credit is not appropriate. And again, here, the biggest thing is that the defendant absconded for about 8 years. And it wasn't that she simply failed to report. She had moved, she had changed her phone number, she did not report to her probation officer, she was taking actions that...
We're not trying to give her credit for that time. We're trying to give her credit for the time she behaved.
But I think...
Why isn't she entitled to... Look, because he revoked her and he imposed the full sentence, so why wouldn't she at least be entitled to the time which she actually behaved? I get why, once she absconded, she's not entitled to that time, but why not the time when she actually behaved and it was working?
And to be clear, the statute for street credit is solely discretionary. It is not, the defendant is not entitled to it. It is not something that the trial court shall impose. It is a may. And based on the egregiousness of this violation, the state submits that the defendant shouldn't be awarded any additional time based on that. That even if she had not violated during that time, the egregiousness of the violation when she did do it warrants, is an appropriate consideration for this court to say, you don't get street credit. And that's just what we submit. Briefly, I do want to touch on your question, Judge Wilson, because there are dates that kind of get tossed around and become a little bit confusing. So the defendant, there's a question in the record about when the initial sentence got imposed. So the defendant enters this petition to plead guilty in exchange for being placed on judicial diversion in June of 2008. The order for deferred probation, putting the defendant on judicial diversion, is entered late November of 2008. But at some point in 2008, she gets put on judicial diversion. In April of 2011, she has a first violation report, and on June 21st, 2011, she admits the violation and a new sentence is ordered. The judicial diversion is revoked, and she is placed on probation, and the record is very clear that the sentence is to begin anew, and it is no longer a 5-year sentence, it is a 6-year sentence. So all from 2008 until 2011, that's all gone. The defendant doesn't get street credit for that, the defendant doesn't get anything for that, because that is part of her agreement for the initial violation. So at best, were this court to decide the defendant should get some street credit, it is from June 21st of 2011 until, I believe the defendant said, September, I don't remember the exact date, when she stopped to report, of 2014. If this court decides to give street credit, that is the most time that she could be awarded.
3 years, basically. Did I hear this? I mean, give or take a month.
Give or take, I think. But again, back to this is discretionary, and should this court decide to conduct a de novo review, the state submits that based on the egregiousness of the violations, the multiplicity of the violations, that this court should exercise its discretion and decline to award any street credits.
Was it the same trial judge in 2008 dealt with her in, I guess, 2022?
That is a good question. If you'll give me 2 seconds to pull the record up, I can.
I'm just interested.
I want to say yes, but the record will more accurately
I'm sure
reflect.
we'll find it.
Yeah.
Where is this from? Chester County.
But again, unless this court has further questions, we ask this court to affirm the revocation of probation and to deny the awarding of any street credit. Thank you.
Thank you.
No, the answer's no.
Different trial judge?
Judge Howe, who just got on the bench last 22.
Yes, Your Honor, Judge Wilson, this was a different trial court. It was Judge Hale. It's not in the record, but he was relatively new to the bench at the time that this case came up. It's also not in the record. Trial counsel was also relatively new to his position. I do think it's a fair reading of the record to say that all of the parties, trial counsel, both trial counsel and the state and the judge, were unfamiliar with this issue just based on arguments presented by the state that basically, Judge, I don't believe that you can consider that, and then the trial court's agreement with that it didn't believe that it could consider the request for street time. I just want to address a couple of things that the state brought up, Your Honors mentioned this case really revolves around, at least on this issue, for successfully served. I do think that is a very broad term. I think it's a very something that lends itself well to a discretionary action by a trial court. And as I stated previously, I think that a remand on this issue would be the best course of action to allow that to be fully argued or fleshed out presentations of proof as to what kind of probationer was Ms. Paul when she originally went on during the time and up until 2014. I would also note for this court, if you're taking a de novo review, that there were no new offenses from the time of 2014 until 2022 when this violation was issued. I think it is a fair reading of the record that she was certainly not reporting in. I do not think that it supports that she had absconded, but just point that out, there were no new offenses. And also she spent over 6 years of essentially a 6-year sentence on some form of supervision. She was originally placed on diversion, which is treated almost identical at a probation office to someone who is just put onto probation. They are given drug tests. They're the same conditions as far as maintaining employment, full-time student, those sorts of things. I believe it's even an identical form that she used. So to split hairs about, well, it's the exact same case, it's the same charge, it's the same number.
Did she agree to start all anew in 2011?
She did agree to her sentence starting over in 2011, but I don't think that necessarily cuts off application of any of that time against her sentence. If she had agreed, because she could have easily agreed to serve jail time and get credit for that, or I mean, there's any number of things that could have happened at that time. But to just say because she's on diversion then, and then her diversion eligibility is removed, that time doesn't count now.
Well, unless the understanding was when they worked out this agreement, we're just going to start all over again. You're going to start a whole new sentence. We're going to agree to put you back on probation as opposed to ask for jail time. So the state, I guess in their bargaining, they said, okay, we won't ask for jail time, but you're going to start this all over again.
There's no indication in the record, or there's no information in the record, let me say, that gives insight into that, other than Ms. Paul readily admitted to the violation, and it was an agreed outcome or a agreed result as from that violation that her sentence would start over, and she would, from that day forward, be on 6 years of probation. She would no longer be diversion eligible. So after completing the probationary period, she would not be able to have that expunged. That's right. It would be on her permanent record, whatever the term is, moving forward. But so again, I think that's just an issue of splitting hairs because it operates the exact same as probation. If there are no questions, again, I would just ask that this court vacate the trial court's decision finding that she absconded and revoking her probation, remand for a new proceeding on that, or in the alternative, if this court takes up the issue of street time, either remand that for renewed proceedings or under de novo review, grant Ms. Paul credits for the time that she successfully served on probation. Thank you.
Thank you. Call the next case, please, ma'am.
State of Tennessee versus Richard